But we are beginning tonight with a big deal, a story you will not see anywhere else because it is an NBC News exclusive. NBC's national investigative correspondent, Michael Isikoff, has uncovered something that is not classified, but that has been treated as one of the biggest secrets of this administration. It is something that the administration has been fighting over with newspapers and with Congress and with all sorts of different groups suing them, who've been trying to obtain what Mike Isikoff has just gotten closer to anybody else to naming. And it is happening, presumably not coincidentally, it is happening right in the midst of really big changes happening right now in national security in Washington. Today in Washington, of course, was Secretary of State John Kerry's first day on the job. He was sworn in on Friday after his confirmation hearing and his confirmation vote process that were, frankly, a breeze. In the end, the Senate vote was nearly unanimous, 94-3, to confirm John Kerry as Secretary of State. John Kerry, of course, will be taking over there from outgoing Secretary Hillary Clinton. John Kerry joked today that he had big heels to fill as the new Secretary of State. President Obama's second major nominee to face a confirmation hearing was another national security pick, former Senator Chuck Hagel. His confirmation hearings for defense secretary were not a breeze. The vote on his nomination has not yet happened. Republicans in the Senate are now hinting that they might even filibuster Chuck Hagel's nomination for defense, which, of course, sounds normal because it, seems like Republicans filibuster everything now. But in fact, that would not be normal. That would be unprecedented if they do it. The reason Republicans are even considering doing this unprecedented thing is because they cannot block Chuck Hagel's nomination by normal means. Even though the Republicans have persuaded lots of the senators on their own side to oppose his nomination, they are a minority. And they have not persuaded any Democrats to oppose him at all, at least none that have come out so far and said they'll vote no. Now, there was that strange effort, what seems to have been a right-wing effort to make it look like there was Democratic and left-wing opposition to Chuck Hagel. But honestly, it was ridiculous, and we had to pull out the bullpucky siren. It was this really ham-handed fake effort to look like liberals were opposing Chuck Hagel, but nobody believed them, and they stayed anonymous, and they never came out of the closet and said who they were, so no opposition on the Democratic side of the aisle, no opposition on the left, except for the fake thing. And that means that the Republicans would have to do something historically unprecedented and truly radical if they are going to stop Chuck Hagel's nomination. Filibustering a cabinet nominee, unprecedented in modern times. Now, they might try it, but it would be a huge deal if they did. A huge enough deal that it might even finally prompt the Democrats to change the filibuster rules. So it's not likely. Now, if you are looking for a high-profile, national security, Obama second-term nominee who really might have some interesting opposition, who really might have some opposition from the Democratic side, if not even from the left, it's not Chuck Hagel. Obviously, it is not John Kerry. Now, the guy you are looking for is the one who is up this week. On Thursday of this week, President Obama's nominee to head the CIA, John Brennan, will face the Senate Intelligence Committee for his confirmation hearing as the Director of Central Intelligence. One of the very first things President Obama did, you might remember, when he first became president at the start of his first term in 2009, was that he dropped the Bush administration's torture policy. Remember, he did that right away. He issued an executive order 2 days after taking office to doubly, triply, extra ban torture in the United States. At the start of that first term, newly elected President Obama also wanted to nominate John Brennan to be the head of the CIA. But he didn't end up putting him forward. John Brennan ended up taking his name out of contention for that nomination because of opposition to him being chosen. And the opposition centered on the fact that John Brennan had been deputy executive director of the CIA during the Bush days, during the bad old torturing prisoners days of the George W. Bush administration. So you're going to have a brand new president who bans torture, but then you're going to put a guy who was there for the whole torture regime in charge of the CIA? Yeah, there was an effort made to make the case that John Brennan had been opposed to the Bush-era torture methods while he had been at the CIA, but nothing in his known professional tenure backed that up, at least not enough to save his nomination. And John Brennan withdrew his name from consideration that year, and he did not run the CIA during Barack Obama's first term. Instead, he got the world's greatest consolation prize. He became a very close White House advisor to the president, his White House counterterrorism advisor. And he was there at a time when the CIA and the United States generally were not known for torturing people. We are not known for torturing people anymore. What we are known for in the Obama era is not torturing people, but rather killing them. On the same day that President Obama signed that executive order banning torture, a couple of days into his first term, he also signed this executive order to close Guantanamo. Now, of course, 4 years later, Guantanamo is not closed, even though that was an almost first-day priority for President Obama. He still says he would like to close Guantanamo, just as George W. Bush said he wanted to close Guantanamo. We have Congress to thank for the fact that it's still open. Congress has blocked the president's options for closing that offshore prison. But notice also that not a single new terrorism suspect, not a single new prisoner has been added to Guantanamo since President Obama has been in office. People have left by a number of different means, but nobody new has shown up since Barack Obama was sworn in as president. We have not been shipping people to Guantanamo, even though the president has not been able to close it. We haven't been shipping terrorism suspects anywhere, really. Mostly that's because we haven't been capturing them, mostly. We've been doing something else. Since 2002, targeted killings, targeted missile strikes have killed as many as 4,700 people, mostly in Pakistan. The highest profile targeted killing, which was not by a drone, which was by a Navy SEAL team, was, of course, the killing of Osama bin Laden during a raid on his compound in Abbottabad in Pakistan. The highest profile drone strike killing was this guy, Anwar al-Awlaki, who's a U.S. citizen. He was born in New Mexico. He was killed in Yemen. But between those very high-profile killings, there have been dozens and dozens, ultimately hundreds of drone strikes under President Obama, most of them mostly unnoticed in the news. On the Monday of President Obama's inauguration, the same day that President Obama outlined this wide-ranging liberal agenda for his second term, that same day there was a drone strike in Yemen. And that drone strike on Inauguration Day followed drone strikes in Yemen on both days of the weekend that preceded Inauguration Day. So we had drone strikes on Saturday and on Sunday and on Monday, the Monday the president was sworn in. It doesn't really make the news. One of the most unusual things about drone strikes for us as citizens in a country that does them is that for so long our country would not admit that we did them, even when we all knew that we did. That was the case. That did not change officially until April of last year, April 2012. And the person the administration put forth to do that, to admit that policy for the first time publicly, was John Brennan.
So let me say it as simply as I can. Yes, in full accordance with the law, and in order to prevent terrorist attacks on the United States and to save American lives, the United States government conducts targeted strikes against specific al-Qaida terrorists, sometimes using remotely piloted aircraft, often referred to publicly as drones. And I'm here today because President Obama has instructed us to be more open with the American people about these efforts.
Why exactly the Obama administration thinks these strikes are legal? They say, let me say as simply as I can, in full accordance with the law, the United States government conducts targeted strikes. In full accordance with the law. We know that they do think it's legal, but they won't say why they think it's legal. The closest we have come to learning about how the Obama administration justifies drone strikes is this. In the fall of 2011, New York Times reporter Charlie Savage wrote this story. This is about a week after al-Awlaki was killed, al-Awlaki, the U.S. citizen who was killed in Yemen. And the story describes a super-secret 50-page memo written by an office within the Justice Department that effectively serves as the Obama administration's legal justification for why they think it's okay to kill an American citizen without a trial. Now, the New York Times did not actually get to see this memo. They did not publish the memo, nor did they quote from it directly. The memo was described to the reporter by anonymous sources. And that's when things got really weird. Because after the Times reported on the existence of the memo, the Times reporter who wrote that story and another Times reporter and the Times itself and the ACLU and other people tried to get the Obama administration to release this memo. Well, somebody from the administration who has high enough clearance to read it is willing to talk to a reporter about it. Please, can we see it? Everybody filed Freedom of Information Act requests. None of that worked. Those Freedom of Information Act requests were denied, and the government refused to confirm or deny that the memo in question even existed. The Justice Department and the Obama administration have refused to acknowledge whether or not the memo exists. Its existence is itself classified. Or should I say, its existence or lack thereof is classified. But the Times did report on its existence. back in October 2011, and they filed their lawsuit back in 2011. And members of Congress have also asked the Obama administration to please release this memo. We know you think it's legal. Why do you think it's legal? The closest anybody ever came to getting the Attorney General to admit that this memo in fact exists was this very, very awkward moment caught on tape during a routine budget hearing back in March of 2012.
I still want to see the Office of Legal Counsel memorandum. And I would urge you to keep working on that. I realize that's a matter of some debate within the administration, but...
That would be true.
That would, can I say that it would be true that there's debate about the... Just last month, a federal judge named Colleen McMahon ruled on the lawsuit to release this memo. So they'd filed a Freedom of Information Act request. They said no. Then they said, okay, it's no longer a request. We're suing you, demanding that you release this memo. And Colleen McMahon was the judge who received that lawsuit. And she ruled in the government's favor. She ruled that the government could keep it secret. The government could, in fact, keep secret their secret justification for killing a U.S. citizen without trial. But what was amazing about this ruling is that the judge was so vocally unhappy about having to issue the ruling. Look at what she said. Quote, I can find no way around the thicket of laws and precedents that effectively allow the executive branch of our government to proclaim as perfectly lawful certain actions that seem on their face incompatible with our Constitution and laws, while keeping the reasons for their conclusion a secret. Quote, the Alice in Wonderland nature of this pronouncement is not lost on me. She added that she was operating in a legal environment that amounted to a veritable catch-22. John Brennan faces his confirmation hearing to be the head of the CIA on Thursday of this week. He will face questions from senators on the Senate Intelligence Committee who will presumably ask him about his time in the CIA of yore under George W. Bush and his time as the face of the drone program under President Barack Obama. One of the senators who sits on the Intelligence Committee who's going to get a chance to question John Brennan is Oregon Democrat Ron Wyden, who's a bit of a contrarian on these issues. Senator Wyden recently wrote a letter to John Brennan asking for answers of his own about targeted killing and about why it's justified and exactly how it is justified. The questions themselves are so basic that they are almost more telling than some of the answers they could but probably won't receive. Questions like, for example, how much evidence does the president need to determine that a particular American can be lawfully killed? Also, this is one that sticks with me. Does the president have to provide an individual Americans with the opportunity to surrender before killing them? And are there any geographic limitations on the intelligence community's authority to use lethal force against Americans? Including, can any intelligence agencies kill people under this authority in the United States? Could the CIA or any other intelligence agency come kill you if the appropriate high-ranking official in the Obama administration, say President Obama, decided that you were affiliated with al-Qaida and you were a threat and you might act imminently to endanger this nation? Could you then legally be killed as you laid in your bed? We may see on Thursday how many of those questions John Brennan will answer. But tonight, 4 days ahead of that hearing, NBC News' Michael Isikoff has obtained a document that comes closer than we have ever gotten to obtaining details about that secret memo that supposedly justifies this, the memo that may serve as the justification for the American government killing American citizens. Tonight, we have exclusive reporting on the contents of that white paper. Joining us now is NBC News national investigative correspondent Michael Isikoff. Michael, thank you for being here.
Good to be with you, Rachel.
So everybody has been looking for this memo. You have not the memo, but a white paper based on the memo. Does it tell us anything that we did not know before about how the government justifies targeted killings of Americans?
Yes, in short, it does. It provides detail. It fleshes out some of the arguments that have been made publicly, and in ways that in some instances contrast with what has been said publicly. Now, to be fair, Attorney General Holder gave a speech last March where he laid out the administration case for targeted killing of Americans. He gave a three-part test. If there's an imminent threat of a violent attack against Americans, if capture is not feasible, and if the attack is carried out, if the strike is carried out in accordance with law of war principles. Well, let's take that first one first. Imminent threat of violent attack. That's the way Holder defined it. When you look at this 16-page memo, which I've obtained, which is a further legal justification, you see that actually they refer to what they call a broader concept of imminence than direct active intelligence of a plot against the U.S. In fact, it explicitly states that imminence does not mean that the United States has to have clear evidence that a specific attack on U.S. persons or interests is underway. If the U.S. believes that the target has in the past been involved in such violent activities and the target has not renounced such activities, it can be assumed that they are an imminent threat now and that would justify an attack. Now, again, remember, we're talking about targeted killings of Americans. We're talking about making decisions based on secret intelligence. And we see in this memo that some of the definitions are a bit more elastic and open to interpretation than the administration has publicly let on.
Well, Mike, on the three parts, so it has to be imminent risk, and you've just described the broader concept of imminence, which is the phrase that's in the white paper. Which is the phrase in the memo, yes. Yeah. And then that there can't be a capture, that we're killing somebody because they can't be captured. There's also an elaboration on that, which seems to me to be quite a wide definition. I mean, I'm fascinated by the fact that we don't really capture terrorist suspects in Yemen and Somalia and Pakistan and these other places where we know American drone strikes have killed people. People get killed there. They don't get captured. The definition for why a capture is impractical also seems to be very, very wide.
Exactly. What the memo says is that there are relevant factors that could be considered, including whether there would be an undue risk to U.S. personnel in conducting a capture operation. Again, that's a factor that was not stated publicly by Attorney General Holder and raises a host of questions. What is an undue risk? Who determines what that risk is? And how is this balancing test met? There's also language in there that suggests that if the host government, where the target is located, is not on board with a capture operation, that could be a reason to conduct a targeted killing as well. I mean, the problem when you go through this memo, and by the way, we're posting it all on NBCnews.com tonight, and people can read it for themselves, is that there's a lot of language in there that is, as I said before, somewhat elastic, somewhat open to interpretation, and can be defined in very different ways by different administrations in the future, by the way.
Michael Isikoff, NBC News national investigative correspondent. Again, Mike's story is now posted at NBCnews.com, and we're going to have the memo up there as well, Michael?
Yes, we will.
All right. Thanks for being here.
Be up there now.
Congratulations on the scoop. Appreciate it. You being here with us. Thanks.
Sure enough.
All right. Lots to come. New York Magazine's Frank Rich is going to be here. Stay with us. We'll be right back.